What's a claim in a bankruptcy? What does allowing it mean? Why am I talking about this? Hi, my name is Scott Goldstein. I'm a bankruptcy attorney. I practice in New York and New Jersey, and I own the law offices of Scott J. Goldstein. Today I want to talk to people very briefly about what a claim is in a bankruptcy case, what an allowance of a claim is, and what that might mean for your particular issue. So a claim is very simply somebody standing up in bankruptcy court filing a form and saying, "You owe me money." And this most commonly occurs in Chapter 13 or 11 cases where creditors might actually seek to recover something. In Chapter 7 cases, this only happens when there are assets to be divided up. If your stuff's all protected by exemption in a Chapter 7, there's no point, and the court does not solicit proofs of claim. Every proof of claim must, by law, be accompanied by proof of the amount owed. Now that can be either a database entry showing a little bit of the account history. It can be a copy of the mortgage. Mortgage proofs of claim are usually accompanied by all the title docs about the mortgage, a loan history, and some other stuff. If it's a credit card, they're usually going to give you a slight bit of account history and a closeout sheet. But what happens when a claim is submitted? Generally, under Section 502 of the code, and I mean the bankruptcy code, a proof of claim is deemed, quote, allowed automatically unless somebody objects. And who's going to object? Generally, the debtor will object, or if it's something really egregious, the Chapter 13 trustee will raise an objection in a Chapter 13 case. In Chapter 7, the trustee might object if he sees something really wrong with it, but many times they won't even bother. At least until a point comes where they're looking at distributions. Why would you object to a claim? Claim can be objected to on many grounds. The most common one is that the amount is not actually owed. So if someone files a proof of claim in your case and you actually don't think you owe the money because of any number of reasons, you can file an objection to claim, and then everyone comes to court and proves up their claim, whether or not you owe it or not. Sometimes it works, sometimes it doesn't. Sometimes you have issues where there is an issue of security, i.e., is there enough money in the case to actually secure the loan? That happens when you're trying to get rid of a second mortgage. You can object to that proof of claim and say, no, it is not fully secured. It needs to be completely wiped clean and treated just like any other unsecured debt, and then they do their thing. There's all kinds of reasons to object. There could be fraud, all sorts of things. But if no one objects, the claim is allowed, and it remains a valid claim against the case. Now, in a Chapter 7, the basic thing is, who the hell cares? It's going to get discharged anyway. If, on the other hand, you have an issue where the lien might remain alive, the claim might remain alive, then you might have an issue. But if there's no personal liability, doesn't usually matter. So that's claims and claims allowances. I hope this is helpful to you. If you have questions, please contact me. You can subscribe to my feed and see what other videos I have out there on these topics. Again, my name is Scott Goldstein. I'm the owner of the law offices of Scott J. Goldstein, and I hope this was helpful.